to share the PowerPoint that we're going to follow. And as most of you know who come to these things regularly at the Senior Center, I normally hand out a hard copy of my slides, which is a lot more difficult to do when we're in a session like this. However, I am happy to email you a printed version or a printable version of the slides if you want one. So if you would like a copy of the handout for this session, this is my email address. I'll give you a second to jot that down. Some of you already have it, I know, but feel free to send me an email to ask for a copy of today's presentation, and I will email that to you. It's quite a large file, so it might take a while to download when you get it. All right. And I think this comes up again at the end of my at the end of the presentation. If not, I'll put it up so you can get it then. So one of the things that I like to do when I'm doing these sessions is to sort of illustrate why I think this is important. And I like to do that by way of a story. And this one is the story of Mr. Jackson. Mr. Jackson is a real person, but that is not his real name. And if you guys are going to talk in the background or answer phones or whatnot, can you please mute your audio?
Police brutality. The war on history. That was George P.
All right. Somebody needs to.
Now they're targeting Lincoln, Washington, Jackson, Jefferson.
All right. I'm going to mute everybody.
Yeah. We need great people in our police departments, and we have mostly great people, but we will do better, even better, and we're going to try and do it fast.
Please turn off your audio if you're going to watch TV in the background.
The backlash from the constant criticism and talks of these.
Oh, jeez.
All right, so I've muted all of you guys, and I hope all of you can hear me. Sorry about that. This is Mr. Jackson. This is not really Mr. Jackson, but this is almost exactly what he looked like when I met him for the first time. He was a resident at a local assisted living, and he was a pretty sick guy when I met him. Mr. Jackson was in his mid-70s. He was completely and profoundly blind. He had very severe diabetes, which accounted for his blindness. And he had been in and out of many nursing homes prior to being admitted to the assisted living where I found him. And he had also been in and out of the hospital. So he would go in the hospital as a very sick person. He would be discharged to a nursing home, and then he would discharge himself against medical advice. And he just continued in this pattern over and over and over again. And he would be found either unconscious or in some state of distress by someone who came to bring him a meal or take care of him or whatever. They would call the ambulance back to the hospital. He would go from the hospital to the nursing home, and from nursing home he would again find his way to his own home. Eventually they discharged him to the assisted living, and he was not even able to get up to walk out. And they called me because he had asked them to call a lawyer so he could write a will. He told me that he had no wife or no spouse. He had no children, had no siblings, nobody in his life. His parents were long since deceased. And the only person that was in his life was a housekeeper who took care of everything for him. And she would come to the facility, and she would bring his checkbook, and he would just sign checks. Remember, this man was blind, could not see what he was signing at all. The housekeeper was also listed as RP, and that stands for responsible party at the assisted living. So they would call her for any decision making without any legal authority to do that, other than the fact that he told them that's what he wanted. So that's how I found him. And he did ask me to write a will, and we had a conversation. I went to see him in person, and he told me everything that he wanted to do, told me that he wanted to leave everything to a particular person. and he wanted to give the legal authority to his housekeeper to act as his power of attorney. In addition to whatever he owned here in Virginia, he also owned his mother's home, which he had inherited, together with a trailer, a bunch of bank of accounts, and a lot of things that I didn't know anything about at the time. Before I was able to draft a will for him, and he paid me, he wrote me a check that day, really 2 days later, I think it was, he went unconscious. He was transported to Martha Jefferson Hospital, and within 24 hours, he dies. And I never got an opportunity to even draft a will, much less have him sign one. And that situation, when someone dies without a will, is known as dying intestate. He had no will, no executor, no estate plan whatsoever. Because he had paid me to write a will and I had no way of returning that money to him or to his estate, I decided to probate his estate myself. It took me 3 years to resolve his estate. The money that we ended up with, I paid to 12 different distant cousins, all of whom he had not seen in more than 40 years. And that is absolutely not what he wanted. I knew that was not what he wanted, but I couldn't do anything about that because he had not signed a will, and his communications with me about what he did want were confidential, so I could not disclose them unless a judge tells me to. So, that's just one of many, many war stories that lawyers like me have when we're talking about the reason you want to do some estate planning. And I talk about this in simpler terms. I talk about what you want to do about your stuff. And if you remember, I also talked about managing Mr. Jackson's stuff while he was still alive, paying his bills, and the fact that he had turned over his checkbook and signed checks blindly, literally, to someone who, frankly, I didn't trust at all. And so I want to talk to you a little bit about what to do about your stuff. And what I mean is, while you're still alive, please consider setting up a general power of attorney. Durable simply means that it continues. Should you become incapacitated, either through dementia or some other problem. And that gives someone else, someone that you trust, the ability to manage your personal business, your banking, your real estate, all those things, while you're still alive. So I'm not even talking about a will here. I'm talking about a power of attorney while you're still alive. You should get a will or a trust, and that is what we call estate planning in terms of our stuff once we die, how that stuff is going to be distributed. And don't forget that you're also going to be handing over your debts to whoever it is that you hand this stuff to. If you have a house that has a mortgage on it, when you leave that house to someone else, you're also leaving them the debt, the mortgage. If it is not paid, the bank is going to take their portion out of that. All of this takes effect when you die, that transfer of assets. However, with a trust, someone is also managing your assets while you're alive. So there's this combination of managing things while you're alive through a general power of attorney and or through a trust. I usually use both. If you are managing your stuff while you're alive without a trust, again, a durable general power of attorney is what's going to give someone the ability to carry out your wishes, not their wishes, in practical matters. So if you hand over a power of attorney to someone to manage your affairs, and they say, you know what, I'm going to put you in a nursing home, and you don't want to go to a nursing home, they can't do that against your will unless you lack the capacity to make good decisions for yourself. So if you have a power of attorney and they're doing things that you don't want to do, you can fire them. You can revoke that power of attorney. Very important to remember, you still have the power. They have a responsibility. So getting a little further into the meat of this stuff for wills, and some of this is a review for most of you. A will, for most of my clients anyway, a will is sufficient. There are very, very few instances where I feel it's necessary to write a trust. I'll talk about that more in a minute. In a few rare cases, you may not even need a will. The laws of intestacy, that situation where you die without a will, do provide for the orderly transfer of property. And by that I mean, if you're married, your stuff is automatically going to go to your spouse. If your spouse has died before you, it's automatically going to go to your children. And in the same way Mr. Jackson's property went to his family, no matter how distant, it's going to go to somebody in that line of succession that's laid out in the law. Now, that is not what he wanted, and it may very well not be the people that you want, which is a very good reason to make a will. For others, a trust might be the best choice, and that little text at the bottom that I had wobbled there for a second, trust has pretty serious implications for your tax situation, or can have very serious impact on your tax situation. So you may very well want to talk to whoever it is that you have do your taxes before you enter into a trust to make sure that that's a good idea. So who does need a trust? There's a couple of things I'm looking for when someone says, oh, I need a trust. Keeping in mind that this is a tool or a vehicle for managing your assets. It's actually both during and after your lifetime. So that's a little bit different from a will. For people who have very complicated tax issues, for example, if you've not paid your taxes and the IRS is coming after you, transferring assets into a trust may protect them. I am not a tax specialist. That's something you'd want to talk to a tax specialist about. If you have a very, very large estate, and what is very large? Very large is more than I think it's 11.5 million right now. Most of my clients are nowhere near that amount of money or property. If you are, please make sure you get my name and address and phone number at the end of this, because I would very much like to take care of your estate, and my fees just went up if you have $11.5 million. This is really hard when it's muted. I can't hear whether you guys laugh at that stuff or not. If you have children or adult children who have special needs, if they're disabled in any way, cognitively or physically, and they're receiving Medicaid or Social Security, you may want to create a special needs trust that allows them to continue to receive money from you without losing their benefits. That's called a special needs trust. If you have a small business or even a large business and you want to transfer that business after your death, you may want to use a trust to do that. Generally not the best vehicle in my opinion, but it's an option for transferring a business. If you have someone in your life who is involved with drugs or gambling or just can't manage their money, you may want to create a spendthrift trust to protect them from themselves and ensure that their money is used to their benefit and not just frittered away. That's called a spendthrift trust. Most of the people I see are looking for something to protect their assets for long-term care, and that is usually called either a Medicaid trust or Medicaid planning or an asset protection trust. That is a very complicated process, and it's something that's really beyond the scope of this presentation, but it is one of the things I talk about a lot. If you've heard about those things, many other lawyers do seminars talking about those things, and I'm happy to talk about Medicaid planning or asset protection trusts individually if you'd like to set up a consult. So all of this stuff, when we're talking about the transfer of property, has to do with what happens when you die. Where is this stuff going to go? Well, I got no idea what happens to your soul. I do know what happens to your property. So really the question is, what should happen when you die? That's what I'm much more interested in. Your executor or personal representative should first and foremost secure your home, change the locks, if at all possible, in some way or another. Make sure that nobody can get into that house. People have a bad habit of saying, oh, Mrs. Jones told me I could have that painting, or they told me that I could have the family silver. and off it goes, and you'll never see it again. You'd be amazed how many people also have keys to someone's house, cleaning people, caregivers, family members that have keys to the house. So I strongly suggest that the very first thing you do is secure the house. Cars, all of those sort of things. If there is a power of attorney, the power of attorney authority dies when you die. You should not be using a power of attorney after someone dies. You shouldn't be writing checks as power of attorney or using credit cards or anything else. You should also not be allowing anyone to drive the decedent's car or move or remove any other property except the surviving spouse. And that will change as time goes on while you're managing someone's estate if you happen to be the executor. But you know, who knows what the insurance says about that, if there's an accident or it's stolen. It's going to make it very, very messy. A lot of people don't know this. I get phone calls all the time from people that say, oh, my mother just died. What do I do? Do I have to notify all these people? And usually you do not need to notify people of someone's death. The funeral home, possibly the hospital or hospice, will send a death certificate or prepare the death certificate. And the minute they do, they will notify Social Security electronically. Your Social Security benefits will stop. They will actually claw back if you have already received the benefit for the month in which you died. They will take that back. So don't let anybody write checks against that account. But they will also notify anybody, any bank, any institution that has business with you that's associated with your Social Security number. So if you have a checking account, if you have an investment account, the IRS, all of those people will be notified automatically that you have died because the Social Security Administration will notify them automatically. If you have other benefits, for example, a pension or veterans pension, all of those kinds of things will stop automatically. It's very likely that if that happens and the bank does not have a joint owner or some other designation on it, that bank account will be locked in pretty short order, so nobody will be able to write checks on it until an executor qualifies. If there is a surviving widow or widower, the Social Security folks will automatically, as I said, claw back the benefit for that month. If you died within the month that you already received a benefit, they will automatically recalculate a surviving spousal benefit for a surviving spouse. And so that will begin very shortly thereafter. Let me just make sure that nobody's stinging me. The personal representative, that is the person who may become your executor, it doesn't have to be. If there is no executor, we usually call them a personal representative, should be collecting all the financial statements, bills, incoming mail. Going back to that example where daughter calls me, oh, my mother died Friday, what do I do? I usually tell them do nothing for at least 30 days, preferably longer, 60 at least. Because you need to collect a whole bunch of information before you go forward. So unless there's an absolutely urgent bill that needs to be paid, please do not go running to the courthouse. Hang on just a minute. It looks like somebody's trying to log in, but well, people should come on time if they want to. If they want to come in. So I'm just going to carry on. Your will, if you have one, I usually recommend that people put it in a safe place, but not a safe deposit box. If you're the executor for someone's estate, please, please, please take a will, if you find one, to an attorney and figure out if it's necessary to probate that will at all. In many cases, it is not necessary. Do not go running to the courthouse to qualify, because it's a big job, and once you start, it's next to impossible to stop. If it is necessary to probate, someone's estate, it's going to be in the circuit court where that person resides, where the person died. So if you died at a hospital or in a nursing home or in your home in Albemarle County, it would be in the circuit court of Albemarle County. If in the city of Charlottesville, circuit court of Charlottesville. The first thing that's going to happen is they're going to ask you to provide a basic inventory so that they can calculate the probate tax at the time that you go to the courthouse. This is probably going to be adjusted later. They just want a basic calculation of what the value of the estate is, the house, the bank accounts, whatever it is that you know about. One of the things that people often tell me on the phone when someone dies is that I'm the executor, and I have to tell you that you are not the executor until the court says you are the executor, and you have to go there in person. Very often you will have to be bonded, and if it's a sizable estate, you will have to take out surety, that is insurance, that says, yeah, you're going to do a good job, and if you don't do a good job, they can make a claim against that surety or insurance. As I gave you the example with Mr. Jackson, if there is no will, then that person is intestate. They have no will. And you would qualify, excuse me, you would qualify as the administrator of someone's estate after a period of time goes by in which a will might be found. A lot of things get forgotten in the fray, and somebody's trying to chat with me here. So while the slides are up, I can't see the chats and things like that. So hold your questions until we get to the end, and I'll unmute everybody, and we can take those questions when we get to the end. So when someone dies, it's amazing to me how much people want to take care of the stuff, and they forget that family members, friends are mourning. They're still trying to resolve a lot of issues. It can be a very difficult time for a lot of people. It's not always a peaceful family gathering at the funeral. 9 times out of 10, there's some problem that's still trying to be resolved. So try to be mindful of other people's feelings. And also that this probate process can be very, very long and complicated. Be patient with those people who believe that they are receiving something through the will. They're going to be calling you night and day, wanting to know how that's going to go. And if you're on the receiving end of that, please be patient in that process. And please do not forget to try having an initial consultation to figure out whether you even need to do that. Excuse me. You can call up the clerk's office at the courthouse if you're unsure of the proper procedure to go forward. Keep in mind that they can give you information about the procedure, the forms to use, the timing of things, but they cannot give you legal advice. Most lawyers, myself included, will do a free consultation. So if you call us up and say, hey, I'm named as the executor in somebody's will, can you help me figure out whether I need to do this and how I need to do it? So let's talk a little bit about the difference between a will and a trust. Basically, they're designed to do the same thing. Their job is the same, and that is to transfer property from one person to another, typically when someone dies, not always, but usually when someone dies. I think of them as buckets, and many of you have seen me talk about the bucket that you kick when you die. I think somebody's trying to log in again. So the difference between a will is what goes into the bucket or does not. The will itself does not indicate what goes into the bucket. And the bucket is your probate estate. That's what this red bucket is. The bucket gets created by virtue of your death. It doesn't get created or not created because you have a will or don't have a will. It gets created because you die. And as I said, you may or may not have a will, but you will have a probate estate when you die unless you do something to prevent that. What the will does, the will is a roadmap to the state as to how, or the court, how that stuff comes out of the bucket. So that's bucket, that probate estate that's holding all your stuff when you die. The will tells everybody how that's supposed to come out. A trust, on the other hand, is also a bucket, and it holds stuff that you put in it, not by virtue of your death, but while you're still alive, you transfer, say, for example, your house, instead of being deeded to you in your name, it is deeded in the name of the trust. Or more precisely, it's deeded in the name of the trustee of the trust. And the trustee is the one who controls those assets before you die. You may be your own trustee in some forms of trust, a little bit too complicated to get into at the moment, but the trustee is the person that controls everything that's in the bucket before you die, as opposed to an executor who controls them after you die. When you die, your assets are distributed according to the terms of your trust, do not go through probate, does not rely on the court, is not a public process. So those are some reasons people want to create a trust, is to avoid all that. And those are all good reasons to do that, but it's a pretty expensive way to go about doing it. There are as many types of trusts as I have fingers and toes, and probably more. It can be an extremely complicated process. It's also can be an expensive process. And the question that you always need to ask yourself is, what is the purpose of the trust? If the purpose of the trust is simply to avoid probate, there are other ways to do that. I'm going to talk about that a little bit more as we go on. Creating a trust, as I said earlier, can have significant tax consequences. Make sure you understand what those are before you start transferring property into a trust. Talk to a tax advisor before you do that. Once again, somebody's messaging me after, please. So one of the reasons a lot of people think that they need a trust as opposed to a will is to avoid so-called death taxes. First of all, there's no such thing as death taxes. That is a politically charged term that one hears around election time most frequently. What they're referring to is a bunch of different taxes, and you're always taxed when you transfer an asset. When you buy and sell stocks for exchange, for example, you normally would pay capital gains if you earned money on them. When you transfer a property upon your death, what you're looking at is the possibility of an estate tax, gift tax, inheritance taxes, income taxes, all kinds of other taxes, which collectively tend to be referred to as death taxes. Estate taxes are taxes that are paid on the property that you transfer when you die. Your estate pays the tax on that. And they can be state or federal or both, state and federal estate taxes. And it is based on the total amount of your estate. So to give you an example, if you own a house and you have a checking account and a couple CDs and an investment account, the entire value of that is your estate at the time that you die. That's what the estate tax would be calculated on. There may be an inheritance tax based on the amount the beneficiary receives. In Virginia, we do not have an inheritance tax. Again, there's that asterisk. The tax laws change all the time. So if you've inherited something in a particular tax year, you'll probably want to check with your tax advisor as to whether you owe any tax on that. So a little bit more about this idea of death taxes. I think I talked about this a little bit at the beginning of this. The estate tax exemption under federal law is now permanent. It was temporary. I think it was initially instituted under George W. Bush. It was relatively low. It was, I think, 1.2 million at that time, and it was temporary, which allowed a lot of lawyers to write a lot of trusts, anticipating that it may not be permanent. It is now permanent, and the exemption for federal estate tax is set at $11,580,000. If you have that much money and are worried about paying estate taxes, please come see me. We can take care of that. You can give away your money, $15,000 at a crack, and that is excluded from gift tax. If you have to pay estate taxes, it is 40% on the amount above the exemption. So if you have $11,580,000, give away $15,000 a year until you get below that amount, and you don't have to worry about it. Virginia, like the federal government, currently exempts estates at the same amount as the federal exemption. Very few people I work with need to worry about that at all. And as I said before, we do not collect a Virginian inheritance tax. Keeping in mind that I am not a tax expert, please check with yours to be sure. A probate tax is levied in Virginia, and the probate tax is paid when you go to the court to qualify as someone's executor. And that is calculated on the value of the probate estate. So only those things that are in that bucket, that red bucket that I talked about earlier, the value of that bucket is what the tax is levied on. If your bucket holds less than $15,000, it is exempt from probate tax. The current rate of probate tax in Virginia is 10 cents per $100 if your estate is more than $15,000. If it's above $15,000, it's taxed on the whole amount. So you're not exempt up to $15,000 and pay only over that. You pay on the whole amount. But what kind of money are we talking about here? If your entire red bucket, your probate estate, is valued at $20,500, that total amount of that tax is $20.50. And this is where I was explaining, if you have more than $15,000, they tax the full amount at the probate rate. In addition to what Virginia charges, the municipality or the county in which you're living when you die can also add to that 1/3 of the amount of the Virginia probate tax. In that example that I gave you above, Charlottesville, or excuse me, Albemarle County. I have a terrible time saying Albemarle. I have an even tougher time spelling it sometimes. Anyway, they would add another $6.84 if your probate estate was valued at $20,500. Not going to break most people's banks. So I like to do this in a visual way because I think it helps. If during your lifetime you've created a power of attorney and you've named an agent to manage your property during your lifetime, and all of your assets remain in your name, you are free to sell, give away, destroy them during your lifetime. So the will does not change that. It does not give anybody property rights until you die. If you have no will and no executor, please write a will and designate an executor. And this is what happens when you die. So you've kicked the bucket over to the other side. That power of attorney authority, not the person, the power of attorney dies when you kick that bucket over to the other side. All of those things that were in your control while you were alive are now in the probate bucket. It gets filled with all of your stuff. If you have no will and no executor, someone, really anyone, can go to the court and qualify to administer that probate estate according to the laws in Virginia or the rules of intestacy. If you write a will, your executor goes to the court, they qualify to be your executor, they probate the will, they pay all the bills, and they distribute anything that remains according to what you indicated you wanted. On the other hand, if you set up a trust before you die, you're creating that bucket on this side of life, you appoint your trustees, you should designate successor trustees. So if you are your own trustee and then you die, someone can step into your shoes. You're also going to designate beneficiaries. You're going to fund the trust while you're still alive and transfer the things that are going to be held in trust into that bucket. And they will be designated as being controlled and owned by the trustee at that point. So if you are not your own trustee, let's say, for example, you name a bank or you name your son or daughter, they are the trustee. The property is titled to Wells Fargo, comma, as trustee, and it's now in the bucket in their control. So all that stuff goes in there. And when you die, during your lifetime, your trustee manager manages the assets. And when you die, some different things happen. All of that stuff is already in a bucket, so it does not go into the probate estate. And after, if you acquired anything that wasn't put into the trust while you were still alive, let's say, after you created the trust, you went out and bought a boat and you didn't title it in the name of the trust, but you just left it in your own name, your will, if this is properly done, would just pour it into this bucket to be distributed by the trust. And then the trust is what tells everybody how stuff comes out of there, or it may create a continuing trust in the name of the family, for example. Special needs trusts, I'm not going to spend a lot of time on this. If afterwards somebody has questions about special needs trusts, you can contact me offline and we can talk about that. Again, this is for people who have children who are disabled or incapacitated and are in need of federal or state benefits like Social Security, disability, or Medicaid. And they cannot receive money, otherwise they would be disqualified from receiving those benefits. We create a special type of trust so that their inheritance would not disqualify them. It can only be used for certain things. And it allows a parent of a special needs child or someone who's caring for a disabled person to allow them to continue to receive their public assistance and also to use the money that you would want to leave them without losing those benefits. So my job, when somebody comes to me and says, Doris, I want to do some estate planning, the reason you might want to go to a lawyer to do this as opposed to buying that form on legal doom, as we lawyers call it, is to avoid that whole process of probate, which is a legal process. It happens in the court. It takes time. There's a lot of paperwork. Remember the probate tax, and while it sounded really low in the example that I provided, the higher the value of that probate estate, the higher that amount of tax is going to be. Remember that if it's less than $15,000, it's exempt. So figuring out how to keep it under $15,000 is my job. And if we do this right, you will not need to probate your estate. A couple of ways that we do that is through joint ownership. Most husbands and wives, already jointly own with survivorship their real estate. Not everybody, but mostly. Married couples do. You can create something called a life estate, which allows you to retain all of your rights to your real estate while you're still alive, and the minute you die, it passes to the person that you designate. We can now create transfer on death deeds for real estate. We can do the same for just about any asset. I can create a transfer on death designation for your car. I'm tangled up in my wires. I can create a transfer on death investment account or IRA. We can create pay on death bank accounts for your checking or savings accounts or for your CDs. And of course, on your insurance or annuities, we simply name death beneficiaries on those. So let me give you an example of how this works. When somebody comes to me, I'm going to ask you, what is all that stuff that you own? What is all that stuff that without some planning is going to go into that red probate bucket over here? So the first thing is usually your house, and I'm just going to make up numbers as we go along. Say your house is worth about $300,000, and you have 2 certificates of deposit at $30,000 each, or $60,000 total. You have an annuity of $100,000 that pays you some income. You have life insurance of $100,000. In Virginia, I run into this a lot. People own a lot of guns, and some of them are very valuable, so I threw that in there. It's what's known as tangible personal property. You may have other personal effects. Those are things like jewelry, artwork, furniture, your clothes, pots and pans. All of those are personal effects or tangible personal property. And all that stuff, if we didn't do anything else, is going to go in the bucket, and that is valued at $580,000. If you total all that up, I just put $580,000 in that probate estate because I did not do anything to avoid that. That means that your probate tax to the state is $580, and either to the city of Charlottesville or to the county of Albemarle or county of Greene or whichever county it is you're in, we're going to add another $184 to that. And that's just the beginning because, frankly, there are all kinds of fees as you go along through the probate process. There's the Commissioner of Accounts fees, there's recording fees, all kinds of things that you're going to run into. So my job, if you come to me, is to figure out, well, we've got all this stuff. How are we going to avoid the probate process? The house, we're going to title jointly with survivorship, or we're going to deed it to the children with a life estate, which means you get to keep it until you die. The CDs, we're going to either title jointly with your spouse, or, and we can do both, add a pay-on death beneficiary designation to your kids or someone else. And that simply means that the day you die, that bank account becomes theirs. They don't have any access to it while you're alive. The annuity, we name a death beneficiary, hopefully a contingent beneficiary as well. In the event, say for example, you have 2 children and one of them dies, you may want to name someone else to back them up. Same with life insurance. The gun collection, we can gift by letter or by memorandum and just designate who that's to go to. Outside of the will, we simply write a little letter, and it does not have to be notarized, does not have to be signed. We simply make a list of that stuff and who it's to go to. So what does that leave once we've done all those things? Your personal effects, we valued at $10,000, which was the gun collection at $10,000. That is the entirety of the probate estate. Everything else stayed outside of probate. And so that's it. And what does that mean? Your probate tax is 0. The tax from the county is 0. The estate tax is 0. And basically, you're free and clear, and nobody has to act as executor. Nobody has to do the inventories. Nobody has to do the accounts. And as a bonus, you may not even have to do an inventory or accounting at all for anything less than $15,000. So just as a reminder, this probate process is a judicial process. It happens at the court. It's public. Those records, that list of everything you own and its value is going to be available to the public. It can be extremely complicated, and it's also sometimes very lengthy. This is especially so if somebody gets in a fight, and that happens all the time. You would be amazed what people will fight over. They will deplete the entire probate estate fighting over something as simple as the silver, the family dishes. it can be very, very expensive and very unpleasant for everyone. So the goal is, again, avoiding probate. You do not avoid probate by writing a will. You avoid probate by planning your estate to pass in some other way. You can do it through joint ownership, by naming beneficiaries, pay on death or transfer on death, and it can be avoided using a trust. That makes it private. The distribution is according to what you said you want it to be in the trust itself, which you, given it's an amendable trust, can be changed. The question you have to ask yourself is, what is the purpose of creating a trust? If the only purpose is to keep it private, there are other ways to do that. The other thing that you might want to look into before you go ahead and say, that's what I want to do, is how much does it cost to do that? And how complicated is it to administer going forward? It can be very complicated. So, you know, those are things that when somebody comes to me and says, oh, well, I have a trust that I created 10 years ago, what I'm looking for when they say, well, would you review this? Well, what was the purpose of doing it? That's what I want to know more than anything else. The most important thing I'd like you to think about going forward is, remember that you're going to be gone when all of this happens, just as Mr. Jackson was gone. And the mess that he left behind, he was fortunate enough that I cleaned it up for him. But that you end up leaving that mess to your children, your loved ones, your friends. Somebody has to clean that mess up. Your spouse, your children, other people, your creditors. So if there's a mortgage or if there are extensive bills of any other kind, that all has to be cleaned up, and they may take over the process of probating your estate if that's out there. And it costs a good deal of money to your estate and the people that you wanted to leave your money to or your property to. That is all that I have. Going back to what I said earlier, my email address is right there on the screen, sort of in small letters there in the blue box at the bottom. I am going to unmute everybody so we can take questions, if I can find it.